Hello, everybody. It is now 12:01, so thank you for joining us today for this special Lunch and Learn session on the proposed Bill M216, the Professional Reliance Act. We've got a lot to cover in an hour, so prepare yourselves for that. For your future reference, we are recording this session, and so it will be available on the PIBC website in January. My name is Deborah Jensen. I'm a planning consultant in the Vancouver Island region and a member of PIBC. I'm currently chairing the RPP Regulation Subcommittee, which is part of the PPAC committee, which is currently working on the professional governance project. And I will be moderating today's session. So I'd like to start off by acknowledging that the Planning Institute of BC recognizes and appreciates that we are able to live, work, and learn on the traditional territories of the First Nations and Indigenous peoples of BC and the Yukon. We recognize and respect the history, languages, and cultures of the First Nations, Métis, Inuit, and all Indigenous peoples of Canada, whose presence continues to enrich our lives and our country. And for PIBC, the Institute's offices are located on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. We do have a great panel here today to help bring you up to date on Bill M216, what it is designed to do, what it will likely do, and what PIBC is saying in response to the proposed bill. So I'd like to introduce you to your panel today. We have Kenna Jonkman, who is our PIBC president. We have Narissa Chadwick, who is the president-elect and chair of the Policy and Public Affairs Committee. And we have Guy Patterson, a lawyer and partner at Young Anderson, who has been a staunch ally of PIBC and acts in an advisory capacity for us. So with that, let's get started. I'll hand it over to our first panelist, which is our PIBC president, Kenna.
Good afternoon, everybody. Yes, my name is Kenna Jonkman, and I'm attending from the unceded and traditional lands of the Clay Tenay. I'm in Prince George, British Columbia. I just want to thank everybody for attending. I know registration was quite high. We've have about 400 people, individual registrations for this Lunch and Learn. And I also do understand that there's quite a few registrants that are not members of PIBC, so thank you for joining us. And I hope you come away with some great impressions of PIBC and planners in general. I'm going to keep my remarks brief. I know you're eager to hear from Guy and Deborah on the bill itself and to answer your questions. But before I turn it over, I do want to emphasize that PIBC exists to represent the planning profession in BC and the Yukon. We do have close to 2,000 members, and those members work in key roles in the private, public, nonprofit, and academic sectors in BC and the Yukon. And really our role is to ensure that land use planning and development are aligned with legislative requirements, promoting community values and well-being, and the promotion and protection of the public interest. Everything we do at PIBC is done in an intentional way to align with our Institute's vision, which is planning as a trusted, influential profession, fostering inclusive, resilient, and thriving communities. We implement this by supporting and connecting and advancing the planning profession in BC and the Yukon through certification, ethical standards, education, and advocacy. This advocacy part is what I'm really proud of, and especially around Bill M216. We have had strong leadership from our Policy and Public Affairs Committee, including our chair, Narissa, and Deborah, our chair of the RPP Regulation Subcommittee on this bill. I hope you come out of this Lunch and Learn with a better understanding about the bill and the Institute's position. And if you are interested in submitting your own comments, how you can do that. And with that, I'll turn it over to Narissa. Thank you.
Thanks for that introduction, Kenna. Yeah, I really would just like to acknowledge the efforts of many of our members around responding to this bill. We happen to have had a policy and public affairs meeting the week that the bill was first introduced, and members got together very quickly to start to focus on the development of a response, and through that process, we've had many other members chime in, and so I really do want to extend my thanks to Deborah, because she's essentially, as the leader of the RPP subcommittee, has taken on much of the leadership responsibility there. And then we've had significant efforts made by our staff to support this work. So I honestly feel really proud of our membership and our staff and how we've been able to kind of come together on this. And I think it is a real illustration of how effectively we can work together on some of these very important advocacy in areas. That's all I have to say. I'll hand it over to you, Deborah.
Work the buttons fast enough. Well, thank you, Narissa, and Kenna as well. I specifically want to thank you for your leadership and your strategic counsel through this past month and a half. As Narissa indicated, it has been incredibly busy working around this proposed bill. We've had multiple parties involved, and we really appreciate their support through this. So before I turn it over to Guy, I did want to provide you some additional context about the bill and what the process has been to date. So as Narissa mentioned, the bill was introduced in late October, just as we were having our PPAC meeting. And so when we became aware of its existence, the RPP Regulation Subcommittee went full speed to prepare an initial response to the province. Prior to preparing that submission in November, PIBC, which was myself and David Block, we had two staff members present, Dave Crossley and Raymond Ken, who met with MLA George Anderson on November 10th. So MLA Anderson is the one who's presenting the bill on his own initiative. It is a private bill. And we did learn from him that really his rationale around this was to implement more housing, getting more housing on the ground. And so that is his motivation for crafting the bill. Following that meeting with him, we did submit correspondence to the province on November 14th. That content for that bill was really at a relatively high level, as we hadn't really had an opportunity yet to do a full analysis of the proposed bill. And that correspondence, if you're interested in taking a look, is posted on the PIBC website. Since November 14th, we've had a chance to really analyze the bill. We've had many discussions internally about what it looks like. We've heard from our membership through informal feedback. We've also been learning from other organizations and their perspectives. So UBCM, LGMA, numerous local governments have been posting comments on the proposed bill and putting forward their own submissions to the province. So one further step we took as part of that full analysis was to seek legal analysis from Guy. And so while his memo is prepared for the PIBC board, it is considered privileged and confidential. What I can tell you is that much of his analysis is consistent with other legal opinions that have been shared widely through the public domain. And most notably, you can find correspondence from Lidstone and West Coast Environmental Law. So with that little bit of a context, I want to pass it over to Guy, who can walk you through the key elements of the proposed bill. So Guy, over to you.
Thanks, Deborah. I'll try to share my screen here. Okay, hopefully that's showing my first slide. This slide will just give you a flavor of what all the rest of the slides are like, mostly black and white with a bit of text and not much more than that. And my only hope here in, I think, about 10 minutes or so is just to walk you through, it's a mercifully short piece of legislation, I should mention. So hopefully my talk will also be similarly brief. But yeah, so I'll walk you through not every provision. I think there's 9 sections, and then there's the 10th section, which is the commencement section. But of those 9, I'm not gonna touch on every single one of them. I'm gonna touch on the ones that I think are perhaps most central and also most perhaps give rise to some or maybe not totally easy to interpret. Maybe I'll just say it that way. So I definitely have been scratching my head about exactly how this legislation would work if it were to be enacted in its current form, which of course is not guaranteed, but assuming it might be enacted in something like its current form. I've been scratching my head to figure out exactly how it would work, legally and in practice. So I'll share with you some of my thoughts, I guess, on that, and we'll go from there. One thing, I'm not sort of a real watcher of the legislature, but in the limited knowledge I have of how the legislature works, I was always kind of led to believe that these private members' bills were kind of like a nothing, and they, no one cared about them. They never went anywhere. But obviously, I don't know if any other private members' bill in the history of BC, or at least in recent history, has generated so much attention. And maybe for that reason alone, it's a good thing as far as spurring some pretty exciting public debate on of course, on a topic that seems to be on everyone's mind. So anyway, at least if nothing else, it's got us thinking about development review in BC and how that works and how that fits into sort of the broader context of development in BC. And I do want to emphasize, I used the word development review. Let me just make sure I'm sharing the right part of my screen, because I would just kind of point out here in the explanatory note, right? It says that the bill provides for the streamlining of development projects and reduction of administrative costs in the approval of development projects, right? So there's always, I guess, kind of a focus on the ultimate goal here being approval. And it's always been my view that for planners in BC, perhaps the word approval should be replaced with review, or perhaps analysis. Anyway, to the extent that the end goal for some people other than planners might be approval, might not just be a review, a deeper understanding. This bill is obviously directed ultimately at getting to yes, and getting to yes, more quickly in a more cost-effective way, and obviously, as we heard from Deborah, getting more housing built in the end. And of course, the bill itself is not specific to housing. There's nothing in here that talks about how the various aspects of this proposed professional reliance model are specific to housing. It applies on its face to all development projects, but I guess the only development that anyone cares about these days in BC is housing. So maybe it's just understood that it's actually about housing and not every other kind of development. but clearly, on the face of it, the words of the bill don't distinguish between housing and other types of development projects. It just refers to development projects. Okay, so the definition section is section 1. I'll go in numerical order, and the real probably the most important definition you want to be looking at if you're trying to understand what this bill does is the definition of submission, which becomes important in section 2. But submission there's a few words within that definition of submission that you want to pay attention to. Technical submission, we don't know exactly what a technical submission is and how that might be different from some other kind of submission. But I would have thought that the reference to a technical submission suggests that in the context of a development project approval process, which this definition is referring to, there might be other submissions that would be considered something other than technical, and that this bill is focused on what it calls a technical submission. Again, a technical submission isn't defined, but it seems to be that word must be given some meaning, and perhaps the role of that word is to distinguish technical submissions from other submissions that might be required to be provided under a development project approval process established by a local government in respective land use. So there's some other important words, I think, required to be provided, not just voluntarily provided. I would have thought that probably means under a development project approval process established by a local government. So under section 461 or 2, I can't remember the section of the Local Government Act, it says local governments must establish application procedures for people who want to apply for permits and bylaw amendments. and those procedures are established by bylaw. So I wonder if perhaps a development project approval process established under this definition means one established by bylaw, but perhaps the process might be established in some other way. Anyway, I think that word might be relevant, might be important in understanding what this act is doing. And then finally, it says in respect of land use. So people might be familiar with Part 14 of the Local Government Act, and the title of Part 14 is Planning and Land Use Management. So I think the reference here to land use raises a question about whether this act is also dealing with, for example, the regulation of buildings, which is done under a different section of the act by regional districts and done under the community charter by municipalities. So is this about Part 14 land use applications, or is it much broader, and does it extend to include things like building permits or perhaps soil permits or other things that fall outside the confines of Part 14? I think that's maybe a question to be, the answer may be revealed if this legislation ever gets adopted and considered by any judges of this province. Okay, so Section 2 is the main event here. I think in this act, this proposed legislation, it says a local government must accept as meeting permit or bylaw requirements any submission certified by a PGA professional acting within their scope of practice, unless it's incomplete or a complaint has been made to the superintendent. And the superintendent is the superintendent under the Professional Governance Act. That's also a defined term. I didn't put it on the screen, but you can find it by Googling it pretty quickly. So that position exists under the Professional Governance Act. That's where complaints can be made. There's no further, at least I can't see any further mechanism or instructions for resolving these complaints or disputes. But anyway, off it goes to the superintendent if a complaint is made. And that's one of the two grounds under which a submission does not have to be accepted. But the main thrust of this provision is local governments must accept any submission certified by a PGA professional acting within their scope of practice unless incomplete or a complaint has been made. I see there's some chats popping up. I think maybe Ray or someone else, I'll leave it to you guys to throw the questions from the chat at me at the end, because I really don't want to take more than another couple of few minutes here. So hopefully that's okay with everyone. Okay, so again, it really does turn on, I think, importantly, the definition of submission here, because the thing that the local governments are obliged to accept under this provision is a submission. And as I pointed to you previously, a submission has a very specific definition with some key terms that arguably leave room for interpretation. But I mean, what we see here is the thrust being local governments shouldn't be second guessing. They should just be accepting whatever these submissions are, as long as they are certified by a PGA professional. There is a dispute resolution provision, which is fairly thin. It just says the matter is referred to the superintendent for resolution. And it's only a dispute between two PGA professionals, one employed by a local government and the other retained by an applicant. So remember in 2, the local government must accept as meeting the requirements any submission certified by a professional. But this Section 3 seems to anticipate a potential dispute between a local government PGA professional and an applicant's PGA professional, in which case it gets referred to the superintendent for resolution. Again, we don't know what the superintendent does, what resolution authority or powers the superintendent has. And if you looked at the PGA and the Professional Governance Act itself, I don't think that act really tells us how the superintendent would cope with or manage or kind of resolve disputes referred to the superintendent under this act. But maybe there's going to be some regulations or other steps taken to clarify the role of the superintendent in resolving disputes. Okay, that's the dispute resolution. Peer review. So a local government may not require a peer review of a submission that's been certified by a PGA professional unless authorized by the superintendent. So there's something the superintendent could do, is authorize a peer review. But Section 5 peer review seems to simply say I don't think a lot more than what Section 2 says, which is you must accept. And then it says may not require a peer review. So I would have thought those two things go hand in hand. But what's really added here in Section 5 is the idea that somehow the superintendent might authorize a peer review. And again, that might be something the superintendent does in the exercise of his or her sort of jurisdiction to deal with disputes presented to them. Liability of PGA professionals. So it says PGA professional who is provided a certification is liable for damages resulting from harm caused by reliance on the certification. So I think that's just trying to perhaps promote, diligence and extra care by PGA professionals by the specter of potential damages liability. I assume that's the policy reason for that provision. There's another provision that says, sort of almost like unlike PGA professionals who are specifically liable for damages, a local government, no legal proceeding for damages may be commenced against a local government in respect of a submission certified by a professional. I've heard some people talking about some sort of residual liability and how this clause maybe doesn't go far enough to fully protect local governments. But I would have thought that in the current world where local governments accept and rely on certifications, for example, by a geotechnical engineer as to safe use, that a local government could rely on that certified report, and in doing so, presumably could escape liability in any case. But who knows what kind of liability might arise and whether or not this provision is broad enough to insulate local governments from any liability that might be created as a result of this act, or liability that might already exist that this provision could be trying to minimize to make local governments, again, more willing and less nervous about relying on these PGA professional reports. Okay, finally, there's this regulation-making power that authorizes the cabinet. It authorizes cabinet to make a range of regulations. And most interestingly, perhaps for our purposes, is setting timelines for development application processing. People who work in local government or in and around local government might know that there are no set timelines for how long a local government must take to process any particular type of application, whether it's rezoning or OCP amendments or temporary use permits or whatever. Nowhere in the legislation does it tell local governments how long they have to process applications. And perhaps as a result of that, applications maybe take longer than some applicants would prefer. And here's just a very recent example of an applicant for a business license in the city of Vernon. And one of the complaints of this applicant was that the city took too long to process and respond to their application. The court observed that the city had an obligation to consider the application and not unreasonably refuse it within the bounds of its discretionary authority. No explanation is provided by the city for the unreasonable delay of over 13 months from the filing of these two different business license applications. So in that case, the court found 13 months was an unreasonably long time to take to process a business license application. But there's not much case law that sort of sets any strict timelines for any application processing in BC. This regulation-making power would allow cabinet to set timelines, to hopefully avoid the kinds of complaints that the city of Vernon was made against the city of Vernon in this recent business licensing case. Okay, thanks. That's all I wanted to say. Hopefully, I haven't gone on too much longer than I was supposed to. But that's all for my formal prepared remarks.
Thanks for that, Guy. I think that's a very good overview of a very short piece of legislation that potentially is going to have quite an impact for the planning profession. Before we get to questions, and I know there are a number of you who submitted questions with your registration, I just wanted to briefly walk you through the submission that PIBC has put together that has been submitted to the Select Standing Committee. I'll keep my remarks really brief. There's a lot of content there, so I would really encourage you to go onto the PIBC website and have a look at it. I did mention earlier that PIBC had submitted an original letter to the province. That was around November 10th. And then we started working on one that was a bit more detailed in nature. In preparing for that submission, there was a lot of dialogue internally between the PPAC committee, between the board. We also heard from other keynote individuals from other organizations, the legal responses that we had seen out in the public, as well as the analysis that Guy did. And we clearly heard from all of that the next submission going to the standing committee really needed to be more specific about how the bill was going to have an impact on primarily the public interest, but also the planning profession as well. We also heard that we needed to be very strategic in how we actually structured our submission. So we took a significant amount of time to take a look at the entire context, looking at what our recommendations wanted to be, looking at the analysis that we would include as part of the submission, and providing some key theoretical examples to note how the bill would actually impact the various development approvals that come in front of us. So really providing a clear roadmap that would help the standing committee and their support staff understand the role of planning and the development approvals process for this audience that may or may not have a lot of expertise in this particular field. So in the end, we produced a 17-page submission that includes a primary recommendation, a secondary recommendation. It provides that supporting analysis, as well as those examples as to how those approvals could be impacted. Specifically, we provided some theoreticals around impacts to environmental protection, impacts to hazard lands, impacts to livability, and building safety. The principal recommendation is for the Select Standing Committee to not move forward with Bill M216. The second recommendation is for the province, through the Ministry of Housing and Municipal Affairs, to collaborate with the communities and some of the key stakeholders, including PIBC, to accelerate the implementation of integrated and effective development approvals process improvements for housing, and to share those best practices through expanded peer learning. So the supporting analysis that was provided in the correspondence was to bevy up to support the recommendations of the 5 fundamental deficiencies that PIBC identified and submitted to the province. And those 5 deficiencies included 1, that the bill is disconnected from existing provincial housing initiatives, including the Development Approvals Process Review, the DAPR, that took place a few years ago, Local Government Development Approvals Program, the Building Permit Hub, and recently enacted legislation on proactive planning for housing. The second deficiency looked at the bill's scope as being overly broad and impacting all forms and stages of land development in all communities and regions across the province. The third disconnect was the bill's prohibition on local government peer review of development-related technical submissions, which would likely lead to adverse outcomes on the public interest, safety, health, and welfare of the public and the environment. The fourth disconnect was the bill's dispute resolution process is considered critically flawed and likely increasing the cost and time for new housing and land development. And finally, the bill displaces registered professional planners who play critical roles in the review of professional technical submissions to protect the public interest. So there's definitely a lot of content in that letter, but we heard very clearly that PIBC's position must be stated upfront and provide all the supporting analysis in the main body of the correspondence. So with that, again, I highly encourage you to go and take a look at both of those submissions so you can get a really good feel for what the content has been that's been submitted to the province so far. So with that, we've got a little bit of time here that we can take a look at some of the questions that have been submitted by you in advance. And I know everybody's getting ready to start on their holidays, and we certainly don't want to take up too much of your time through this lunch hour, but let's see how many of these we can actually get through. So in terms of questions that came from you, one of them was, would this bill impact the RPP process and require all practicing planners to become RPPs? It is our understanding that there really is nothing in the bill as it's proposed right now that would identify the professional standing of a planner. The content of that bill really focuses around certified professionals, which is currently not the Planning Institute. We are not part of the profession under the Professional Governance Act. There are a series of 6 or 7 other organizations so far that currently fall within that scope. We are not one of them, so it would not impact us in that respect. There's nothing to say that any planners out there would have to be an RPP. We would certainly encourage everybody to follow through with the full membership, but it's not a requirement of this bill specifically. Aside from building and development permits, are any other municipal processes or applications seen to be affected by this bill? Guy, you alluded to that a little bit in your presentation. Is there anything that you can expand on for that?
Give me that again. I was just reading the chat, sorry.
Sure. Aside from building and development permits, are any other municipal processes or applications seen to be affected by this bill?
Well, I think that's maybe one of the questions. Would it apply, for example, to a rezoning or a temporary use permit or a development variance permit? I think development permits are probably the most obvious thing that it would likely apply to, and I'm not convinced it would necessarily apply to building permits, although I think maybe others say it obviously does. But yeah, I think it would certainly go beyond development and building permits, assuming it does apply to building permits. But I would have thought it would also capture what I call the Part 14 approvals, and maybe even some Section 8 community charter regulatory approvals as well. There's nothing in here to specifically distinguish any of those varieties. It's just as long as it's in respect of land use, whatever that means.
Okay, so it could potentially have a broader impact, which we will likely find out as we go through this process. Can municipalities still reject a submission even if it's certified as complete by a PGA professional? Guy, I think I'll turn that one back to you.
Yeah, it's funny. That raises the question of what exactly is being certified when the professional is certifying a submission. But I don't know that they could certify completeness. I mean, this seems to suggest that determining the submission is incomplete might be still within the purview, the scope, or the discretion of the local government. I don't know that a PGA professional could kind of overcome that by saying, I certify that it's complete. That seems like perhaps a little bit of a stretch. But other than incompleteness, I think the idea is to leave very little room for questioning and not simply accepting the submission.
Okay. Following from that, has an incomplete submission been defined?
No. I think that would be for the local government probably to decide, but it would have to be within the scope of what their bylaw or permit requirements set out. Okay. And I think importantly, that's why I referred back to development approval or development review procedures bylaws. And so certainly if by bylaw you set out what constitutes a complete submission, that would probably be the starting point for determining whether the submission was complete or not, is whether it met whatever your bylaw says about the particular submission.
Okay. This next question, I think maybe I'll get all of our panelists to turn their cameras on. Maybe everybody can provide some input onto this one. Do you know of other places where professional consultants are not peer reviewed, and how do their approval systems compare? I don't know if anybody's got any experience with that. Is there anything we can offer on that question?
I just anecdotally know that Ontario is going through something very similar, but I don't have any context or background to it. I think that would be something that moving forward, because we've been in a state of reaction, that's something that PIBC could look at long term. And we could look at the committee to provide more research and robust response to that question.
Narissa, any comments on that? No, okay.
Yeah, I don't have anything to offer. I'm sorry.
Guy, any follow-up on that one? We've kept you busy answering some of these questions.
I'm just trying to read the question again. Can registered professionals refuse? Give me the question again.
Sure. Do you know of other places where professional consultants are not peer reviewed, and how do their approval systems compare?
I don't know any other places. Sorry. No.
Okay. Can registered professionals, such as planners and engineers, refuse to accept a professional reliance report? That's an interesting one. If you're working in a local government setting, so first of all, planners are registered professional planners, but they're not under the PGA. Engineers are. Could the engineer, let's say it's a traffic report, for example, could the engineer refuse to accept a professional reliance report, or would that deliberately or directly go straight through to the OSPG for
I think that Section 2 says a local government must accept the submission that's certified. So I don't think it matters whether the person in the local government is a registered professional. Now, it does say, except to the extent that there's a dispute between a PGA professional employed by a local government and a PGA retained by the applicant. So maybe that's what this is referring to. So perhaps Section 3 sort of suggests that perhaps another PGA professional that's employed by the government can somehow refuse to accept, and then it gets referred to the superintendent.
No straightforward process here yet. Okay. Now, we had this question coming in as part of the registration, but I see somebody asked about it in the chat box earlier as well. What would be the impact of this bill to the approving officer's role? Do we know if there's any direct connection there?
I thought about that very briefly, and this talks about a local government accepting, and in my view, a local government, at least as it's defined in the charter, community charter of the Local Government Act, does not include an approving officer. An approving officer is an independent sort of officer appointed under the Land Title Act. So I don't think an approving officer is caught by Section 2 of this act, the way it's currently drafted, would be my view.
Okay. What would be the advantages and disadvantages of RPP being included under the PGA, and how would Bill 216 affect the same? That's an interesting discussion. So first of all, the planners, as we've already talked about, are not part of the PGA. The RPP Regulation Subcommittee, through the direction from the PIBC board, is actually working on that project right now, where we have been engaging with the membership just to try to get a feel for what the membership thinks about would we want to be included under the PGA. I have to stress the fact that ultimately it would not be our decision. That's something that lies with the province as to whether we would be included or not. But we wanted to know what that would look like. What are the potential pros and cons of that process? So again, we're not part of the PGA right now. What would it mean for us if we were part of the PGA? I think that would reflect what Guy was talking about as far as the engineers and what would their ability to be to reject or accept an application. So there is potentially something there, but at this point in time, we're not part of the PGA, and it would be up to the province if we were or were not part of that program. Guy, anything else that...
Nope. That's not a question for me.
Okay. What else have we got here? Who is the superintendent, and what expertise do they have in land use planning, urban design, and infrastructure planning? What I can tell you is that the superintendent is the head of the OSPG, or the Office of the Superintendent of Professional Governance. The current superintendent, the official person, is Kate Haynes. I can't speak for their specific expertise, but I can tell you that their overall focus is on the public interest. And so currently they oversee a number of professions, specifically with an interest in the natural and built environment. And so how is the public interest impacted through that particular lens? So while PIBC does not fall under the auspices of the OSPG right now, I think it's fair to say that we have been conversing with their department through the work that we have been doing already on the professional governance project. We did engage with them on the proposed bill that we're talking about here today. So they are definitely aware of the planning profession. So hopefully they're becoming more familiar with planning and its role in all of these development processes as well. How are local governments feeling about the potential increased liability, for example, with subdivision? Again, I don't know that we can specifically speak to municipalities and what their position might be on any of these, but I can say that we have seen a number of municipalities providing statements and submitting their positions to the province about the bill. View Royal, Enderby, Saanich, Victoria, Delta, Nanaimo, White Rock, many municipalities are providing that input over to the province. And of course, UBCM acting on behalf of all of the municipalities. Guy, are you hearing anything more about the liability issue? I know you spoke to it a little bit earlier.
Well, everyone loves to raise alarm bells about liability. And just to be a contrarian, I would have thought that, if anything, this act introduces at least an attempted shield against liability in Section 8 that says no proceeding for damages lies or may be commenced or maintained against the local government. I'm talking fast, but you can read it yourself, Section 8, in respect of a submission certified. So I would have thought that, again, there's a question as to how far and how broad and how complete that immunity is. And I'm not giving you a comment on that. But what I'm saying is there is no such provision in any other legislation that I'm aware of. So if anything, this act brings some, at least attempts to address or create some liability reduction in the world of reliance on these reports. Again, I'm not saying there is no liability, and then I'm not saying that provision is perfect or even useful, but certainly it's more than we have today, as far as I know. I'm not aware of any equivalent provision in any current legislation. So I just leave that with you.
Okay, thank you. I see somebody in the chat has asked, doesn't this bill risk simply adding another layer of bureaucracy to the approvals process and therefore do the opposite of streamlining applications? I think I could unequivocally say yes, it would. And we have actually addressed that in the submissions that we've provided to the province, that it will actually slow things down substantially. What do you see as the risk and liability impacts of Bill M216 on building inspection? Guy, I know you've already talked about that one as well. Anything else that we want to add to that?
Well, I guess, again, to the extent that this does apply to building inspection, I think the idea would be if someone certifies that a building meets the code, then the building inspector is not allowed to, kind of question that. And then presumably it would follow that the building permit, would be issued. And I will say that there is already a provision in the Local Government Act that kind of says if a building inspector relies on a professional certifying code compliance, then there's kind of immunity in respect of potential loss or harm caused if that building turns out not to be built in accordance with the code. So I'm not sure that Bill M216 has any significant risk and liability impacts on building inspection.
Okay. I'm just having a quick look here through the chat box to see if there's anything we can address beyond what we've already talked about.
There is I'll just keep rambling here because there is a note about how some municipalities already do not do inspections. They just rely on outside professionals. And I think that's specific to building to building regulation. And I gather that this bill is sort of modeled on what they call the certified professional program that's been introduced by some municipalities in the building regulation sphere, where again, basically an outside independent third party certifies compliance with the building code, and then the inspector need not do the usual reviews and inspections. And I think really the question, one of the big sort of policy questions I think for this whole bill is, does that model, which seems to be working for some municipalities in the realm of building inspection, does that transfer over, and can that work in these perhaps grayer, more legislative discretionary worlds of some of the permits and bylaw processes that aren't perhaps as cut and dry and black and white as a building permit and the building code?
Okay. We have another question in here, a little bit of a different slant, saying if PIBC was currently part of the PGA, would this limit or negate our ability to advocate on behalf of the profession as we are doing? So, Guy, maybe we can talk about that from a legal analysis for a second. So I think there's two different things there. There's the PGA, and there would definitely be some restrictions on advocacy work if the planning profession was under the PGA. But I want to be careful about how I word that, because there's the planning profession and then there's individual planners, and what advocacy, how you define that, what that might look like in any given situation. But is there any impact on advocacy as part of the Professional Reliance Act as proposed? And I think that would go maybe towards the submission. What is being submitted? What are you advocating for as part of that submission?
I have to say, I don't know the PGA, the Professional Governance Act, and remember that's different than this Professional Reliance Act. I don't know the Professional Governance Act very well, and I certainly don't know if once you become a member of a profession under that act, it affects your ability to advocate. I just don't know what the answer to that would be.
Okay, that's fair enough. Okay, I see we are just 10 minutes away from the hour, so I want to just close up our session here. We've covered a lot of territory. In summary, we know that Bill M216 has received second reading and that it is now going through public consultation until January 6th. So I would certainly encourage all of our members, whether you're for or against, to get your submissions into the standing committee before that January 6th deadline. They will be reviewing all of that material post January 6th. And Ray is going to post some stuff in the chat box so you can see the links to this information. So again, we encourage people to submit input to the Select Standing Committee. We certainly encourage you to go onto the PIBC website and review the two pieces of correspondence that we have submitted to the province so you can get a really full understanding of the content and what we've been talking about here today. Similarly, if you've got any feedback for PIBC, you can email PIBC, submit your information there, and we're certainly happy to have more of a conversation with you as part of that. So with that, I'll go back to our panel. Does anybody else have any other comments they want to make before we close this off today?
No, I just want to say thank you, everybody, for attending. I know there's some questions in the chat that haven't been answered. We will look at those, and as we continue down this path, so following January 6th, if there's a need for more webinars, more lunch and learns, we will work with the committee and staff to provide that to the members.
Guy, any parting remarks?
No, thanks for having me.
Narissa?
Yeah, no real remarks except thank you, Guy, for joining us, and Kenna and Deborah. Really appreciate the webinar.
Yeah, well, thank you. And again, thank you to our panelists. Thank you to everybody who's attending today. I know this is a high visible, can't talk anymore. Quite a visible issue that we're talking about here today is receiving a lot of interest. So thank you for participating. We'll certainly provide more information where we can. And thanks to staff. They have put so many hours into this already. I really want to acknowledge that for them. It's very much appreciated. So with that, I'll say goodbye to everybody, and we will see you again soon as we continue working through this.